Good morning, everyone. My name is Christopher Bopst, and I'm honored to be chairing this panel this morning, which is going to be on whether the New York State Constitution can be shortened, and if so, how. And like my predecessor of the first panel, Peter Gailey, I will not be introducing people. All of the information biographical about myself and the members of the panel is in the bulletin, so you can feel free to refer to that. The British writer and editor Robert McCrum wrote an interesting column a few years ago in The Observer in which he lamented the, quote, literary elephantiasis symptomatic of modern books. In fact, his subtitle of his article not only accused but convicted Jonathan Franzen, Tony Blair, and Ken Follett guilty of, quote, crimes against brevity, unquote. Okay? Were such a crime to exist, the New York State Constitution would certainly be on trial, and indeed a habitual offender. But we're not here to just talk about the length of the Constitution, and certainly it is a very lengthy document, and both in comparison to the federal Constitution as well as to several other shorter state constitutions. But in many ways, we talk about the length of the Constitution as synonymous with this Constitution is not effective, and it's not doing what it should be, and it contains things that make it difficult for the modern New York to function in a way that's beneficial to the citizens of the state. And I think length is not synonymous with ineffectiveness or cumbersomeness. In fact, War and Peace, depending on your version, has between 560 or 590,000 words. Catcher in the Rye has 75,000. But they're still both great works, and people love them both. The problem with the New York State Constitution, though, is unlike either of those wonderful novels, we're talking about a book that's been written over the course of 120 years with different authors writing in different time periods. And when you merge them together, just like if you took chapters from a whole series of great novels and put them together, there'd be a lot in there that wouldn't make a whole lot of sense or could be changed. So I want to talk a little bit briefly about how we got to where we got, as well as some things that can be done to make the New York State Constitution both shorter and more effective, because much of the proposals that would make the Constitution more effective would indeed have the effect of shortening it, because it's been layered over the course of time. Things get added, but things don't get taken out as easily. Sometimes they do, but usually they don't. So that's what you have. You have a layered Constitution that's been the product of multiple constitutional conventions, because even though the current Constitution, based upon your arguments are made that it can be either 1894 or 1938, my position is that it's the 1894 Constitution that was substantially revised in 1938. But many of the provisions that were put in 1894 were dated back to 1846, some of them even to 1821. So you have a layering that's occurred, and there has not been that comprehensive removal of provisions that may have at one point in time served a very valuable purpose, but may not either have the same purpose now or may not have the strength to carry them as they did when they were enacted. So a few of the reasons why the New York State Constitution has grown steadily over the years are, number one, is a distrust of the legislature. And that goes all the way back to the Constitution of 1846, when, following economic disasters that were caused in many part by the legislature investing in railroads and companies, the convention was determined to limit the power of the legislature, and they did. There's a series of provisions that impose substantive, I'm just getting used to my new tongue here, substantive and procedural limitations on the legislature that are found in Article 3, but most of those are easily avoided. There's a a series of restrictions on what can be done with private and local bills that, could affect the legislature's ability to legislate concerning particular cities. So what does the legislature do? They pass a law that applies to cities with a population of over 1 million people. Well, guess what city they're talking about? If they want to deal with legislation based towards, other cities, they can adjust the population accordingly. And that is a way that some of the special legislation requirements are circumvented. So you have a provision that is not effective and not doing what it was originally designed to do, and which at this point in time may not even be necessary because the same factors which caused that distrust back in the 1840s may not be as prevalent today. Now, a lot of people would say, "Oh, they sure are," but but nonetheless, there hasn't been any examination as to whether that's the case or not. In addition, there's one of the other factors which has caused the Constitution to grow is a desire by groups to ensconce certain policy matters and provisions into the state constitution, giving them a permanence and an immutability that would not allow them to be amended or modified by the legislature. And that happened back, again, dating back to the 1846 Convention, which constitutionalized state canal policy, and also the Free Banking Act, which prohibited special incorporation of banks. So New York has a long history, as do many states, of constitutionalizing matters that, in order to provide an extra layer of protection. And at the same time, when these matters, or when these different provisions are added into the Constitution, it's not necessarily studied, or the argument of, well, is this something that is fundamentally necessary, which is kind of what was discussed earlier this morning, is kind of pushed by the wayside because people want things done. Interest groups want this legislation, want these matters put into the Constitution. And a byproduct, a corollary of that is the ease with which the state constitution can be amended as opposed to the federal constitution. The original New York Constitution, 1777, not counting the preamble, which included the Declaration of Independence, was roughly about 5,200 words, which is approximately 1,000 more than the federal Constitution at the time it was enacted without amendments. So at the same time, since 1789, approximately 11,500 amendments to the federal Constitution have been proposed, and only 27 have made the cut. And there have been no other federal constitutional conventions since then. Now you look at New York's history of amendment. We're now on our 4th state constitution. We've had 9 constitutional conventions, which have resulted in, if not new constitutions, substantial revisions to the Constitution, and a slew of different amendments. So the fact that, one can only wonder if the federal Constitution was as easy to amend as the New York State Constitution, how long would it be today? It would probably be considerably longer than it is right now. Also, there's an insistence upon the Constitution makers to insert overly detailed provisions in the New York Constitution. And I'm going to borrow a quote from one of our panelists who you'll be hearing from next, Alan Tarr, in his wonderful work called Understanding State Constitutions, in which he, in discussing the judiciary articles of many state constitutions, he used the quote, "For some state constitutions, no detail appears too minor for inclusion." And certainly that can be said in many ways about the New York judiciary article of the state constitution, which is as we've heard this morning, certainly an article that gets a lot of criticism for being overly detailed and earns every one of those criticisms. The judiciary article reads in many ways more like a code than a constitution, and in many situations it provides code-like provisions and then says, but the legislature can change this if it wants, which now means that you're putting in a certain framework. You're not even giving a mandatory provision in many cases. You're giving a provision that's in effect more of a guideline. But at the same time, it also includes other provisions that make it difficult to adjust to the changing needs of the court system. And that's something that's historically been an issue in every constitutional convention that the state has had. Dating all the way back to 1821, there have been constant revisions to the judiciary article, many of which probably would have been avoided had the state used a smaller, more truncated version of the judiciary article where they did give more power to the legislature. And just by way of comparison, the New York's judiciary article is approximately 15,000 some words, 15,400 words. That is approximately double the length of the Texas judiciary article and the Florida judiciary article, and it's 12,000 more words than the California judiciary article and the Illinois judiciary article, and those are the 5 largest states in the country. So certainly it's not just a question of, well, this state has a large population, we're dealing with significant work, we need a well-detailed judiciary article, because other states have gotten by fine without that much detail, states that have comparable population sizes and are dealing with similarly complex matters. So what can we do about this? What are some things that can be done, briefly? Number one, housekeeping. And that would be removal of material that is obsolete. There are provisions in the state finance article of the Constitution that deal with issuance of bonds to World War II veterans and for removal of railroad crossings at grade, which were certainly necessary at the time they were enacted, but at the same time now those bonds for the railroad crossings have been retired 25 years ago, so I don't think there's a need to keep those kind of provisions in there. Those could be removed. There are also provisions that are inconsistent with federal judicial decisions. There's an apportionment provision that gives every county an assembly seat. That's been held to be invalid about 40 years ago, so that can be removed. There's also a state senate provision that provides that no county can be divided in the formation of senate district lines. Again, unconstitutional under federal law. But yet these provisions, even though they're not effective anymore because of the supremacy clause, they still remain as part of the Constitution, and they can be removed and indeed should be removed. If we really believe that a Constitution should tell the state how to be governed and should govern the state, then it shouldn't contain language and provisions that are not operative because they're unconstitutional at the federal level. 3, there's can be removal of duplicative or inappropriately placed provisions. There's, for example, the housing article of the Constitution starts off and says the legislature has the right to enact legislation relating to housing and slum clearance. Then it turns around and has 9 more sections that really, in essence, say what the legislature can do. I mean, certainly a broad policy prescription, if one is even necessary, should be sufficient to allow the legislature to carry out that policy without then having to include additional sections that say all of the things that the legislature can do, following the general inclusion in the first section of what it can do. Also, the inappropriately placed items, the Bill of Rights, and references was made earlier, has language about divorces, drainage ditches. These are things that one would not customarily associate with the Bill of Rights, and and to have them in the same article of the Constitution that deals with issues such as rights for accuseds and freedom of speech in the press, really somewhat, it's incongruous. It demeans both the existing provisions that are in there, and it creates a much longer, difficult to work with document. The other thing that can be done is certainly there can be an elimination or substantial reduction of certain policy areas that are now firmly committed to the legislature. Again, when the housing article was enacted in 1938, there were issues about or concerns about whether housing was a function that the state government should be involved in. Well, that's now pretty much a settled issue that, housing is a public interest and the state has the right to get involved in it. And so to now have these provisions in there that may have been necessary at the time, given the existing case law, which has now changed tremendously, it's just not necessary anymore. There's, again, nobody disputes that the state has the right to inspect prisons. Nobody would even think that they wouldn't. But yet there's a provision that says the state commissioner of correction has the right to go in and inspect institutions for confinement of felons. Well, some of these provisions, again, whether they should have been in there in the first place is an interesting academic discussion. Whether they need to be in there now is certainly something that's probably a settled point. And there are numerous areas that can be either simplified or reduced substantially. The judiciary, I'm going to defer. I know one of my panelists that's coming up next, Dan Feldman's going to talk about that. But certainly there are, as I mentioned earlier, New York has a much larger judiciary article than many other states. There are ways that can be simplified tremendously, both in terms of jurisdiction and merging courts, which have been proposed but never implemented. And the other thing is the forever wild provision, which I understand is something that in itself is something that's important to many New Yorkers, and it's something that is a very valuable provision that's been rigorously enforced. At the same time, some of the amendments that have been voted on concerning that article, and there have been 14 since it's been enacted, have involved whether the state can swap out 6 acres in the forest preserve in exchange to getting 10 acres from National Grid. Now, the forest preserve is approximately 3 million acres. There could be some type of de minimis exception included so that the voters of the state don't have to vote on whether 6 of those acres can be transferred in exchange for getting 10 back. And the state's been very good in its deal making in this regard, because most of the time they get more acres back than they give up. So it's not like the legislature is going to turn around and start giving away big chunks of the forest preserve, because in all of the amendments that have been approved, there have been more land coming back to the state than given up. So is that something that the voters of the state really need to be voting on? Is that something that is necessary? Or there could be a supermajority requirement in order to prevent needless alienation of the forest preserve. So certainly these are not a comprehensive list of ways in which the New York Constitution can be shortened. Certainly if we took and gave a copy of the document to everyone in here, I'm sure everybody could come up with some of their own suggestions as to how the document could be shortened, made more effective, or simplified otherwise. But and I'm going to now turn the panel over to Dan Feldman to talk about his thoughts about this issue. But certainly, to the extent that this group can lead to, or I'm sorry, tripped myself up. I'm sorry. I'm going to turn it over to Alan Tarr, who's going to talk about the comparative dimension. But certainly, to the extent that this group can cause or affect some simplification or making of the Constitution more effective, then this will have been a productive start. So I'm going to turn it over to Alan now. Thank you.
Thank you, Chris. I'm no expert on the New York Constitution. Let's make that clear at the very outset. I'm here because presumably what's been done in other states may be relevant to what can and should be done within New York. The problems that states confront are typically similar, and the solutions that states have found, other states have found, may be appropriate for New York as well. Some of these have worked well substantively. Some of these have proved palatable politically, which is always a consideration when you're thinking about state constitutional reform. Probably the best advice I ever got on state constitutional reform was from a Louisiana legislator who said, "If it ain't broke, break it." And I think that instead of worrying about the great respect we have for the document, you have to take these as working documents. These are very different than the federal Constitution. Federal Constitution is a relatively short document. These are changeable documents, and they're changeable, following the sort of Jeffersonian notion that every 20 years we should reconsider our constitutional foundations again, maybe even in between as well. Just a couple comparative notes. In terms of the number of words, the New York Constitution's 13th in the nation. The largest by far is the Alabama Constitution, 330,000 words. Or as someone told me there, 2 chapters shy of Moby Dick in terms of the length of the document. In terms of the number of amendments, New York is 8th. And this is actually somewhat surprising because New York has a relatively difficult, there's two passages in the legislature before it goes to the populace for ratification. So you've averaged roughly 2 amendments a year, slightly less than 2 amendments a year. Alabama had, again to pick on Alabama, had 13 amendments on the ballot this year. But in thinking about length, it seems to me form should be determined by function. What do we want a state constitution to do indicates what we should put in the state constitution, what we should leave out of the state constitution. Now, all constitutions, federal, state, are expected to do certain things. They're supposed to establish offices. They determine how you fill the offices. They divide power among the branches of government. They establish limits on government, including rights guarantees. If the responsibilities of state government were the same as those for the federal government, the state constitution could look like the federal constitution. But the state situation is different. First of all, legislative power under state constitutions is a plenary legislative power. The state constitution does not grant power to the state legislature. The assumption is that the state legislature has plenary legislative power, and so the state constitution limits it. And therefore, if you want to have a limited legislature, you're going to have to put a lot of limitations specifically in the state constitution. So it will be longer. The tasks of state government, likewise, are different. Federal government is not concerned with local government in a direct way. It's not concerned with public finance within the states in a direct way. It's not concerned with education in a direct way. It's not concerned, at least until amendments, with suffrage qualifications in a direct way. And so you have articles within state constitutions addressing these matters. The entire US Constitution, in a sense, is the federal plus the state. And so what the federal doesn't deal with, the states may have to deal with. And so the state constitution will be longer, but it's not inappropriate that it's longer because the role of the state constitution is different. In addition to that, states may choose to address things that are not obligatory. So you have in New York an article with regard to conservation, with regard to social welfare, with regard to housing. Again, these are not necessary to put in the Constitution, but they're a way of expressing a commitment by the state on these matters, which are matters of important concern. So what we put in the Constitution, beyond those sort of basics, is a matter of choice. Generally, the more that's constitutionalized, the narrower the discretion for office holders. It's sort of a zero-sum game. Now, this isn't completely assured. Some previous panelists talked about workarounds. If things are too precise, legislators, oftentimes in connivance with the judiciary, finds a way to get around those difficult limitations. But it can make a real difference. If you compare, say, the New York guarantee with regard to search and seizure, it includes specific recognition of wiretapping, something you don't find in the federal Fourth Amendment. If you look at the New York Constitution with regard to education, you see a discussion of funding for religious institutions that you don't find at the federal level. And so we have long, difficult, oftentimes very unsatisfactory court decisions trying to deal with these issues, whereas they're dealt with quite specifically in the Constitution, saving at least some judicial labor. State constitutions, again, in contrast with the federal Constitution, can constitutionalize obligations. These are meant to guide or to channel legislative discretion. On education, what Jerry Benjamin brought up earlier, on social welfare. The idea is the legislature can act, it has plenary legislative power, but in acting, we want it to take these considerations into account in how they act. You may also find directive principles in the state constitution. The Bill of Rights for Local Government in Article 11, Section 1. Again, not necessary in one sense, but it does provide guidance for the legislature. And it may be an important thing to put in. In addition to that, and what people have focused on most, it seems to me, in the previous discussion, is what oftentimes referred to as constitutional legislation. Things which could be legislative enactments, statutes, but find their way into the Constitution. Often they find their way into the Constitution for some reasonable reasons. The legislature may have been unresponsive to public demand, and therefore you do an end run around the legislature. Harder to do unless you can get the legislature, unless you can get an amendment proposed, but you want to have some way of getting around the legislature and getting something enacted into law. You may also put what sounds like legislation into the Constitution to deal with disfavored judicial decisions. A lot of states, after the Kelo decision at the federal level, changed their law with regard to eminent domain, put it in the state constitution, so that individuals who are private property owners didn't see their property taken and give it to another, presumably more economically lucrative private property owner. You may put stuff in the Constitution to preempt feared judicial rulings. A lot of states put bans on same-sex marriage into their state constitutions because they were afraid that the state Supreme Court might find a constitutional right to same-sex marriage. And you may put things in the Constitution because you just fear government generally. Limits on borrowing, so for example, that you find in a lot of state constitutions, including New York's. The easier it is to amend, the more likely you are to get state constitutional legislation in the state constitution. Having said that, in the reasons why this might occur, there are reasons why you might not want this. You need flexibility. You need to respond to changing conditions and challenges. The obvious counter to that is, but what if you distrust the people whom you're giving the flexibility to? So there's sort of an underlying current to this. To what are you thinking of the state constitution as a way of empowering government? Or are you primarily thinking of the state constitution as a way of limiting government? And that sort of choice sort of will underlie a lot of what you do in terms of what you put into the Constitution or not. It's also possible, as and again, Chris pointed to a number of provisions, it's also possible that some things may just seem inappropriate in the state constitution. Notice, that's just housekeeping. The fact that you have something in the New York Constitution with regard to ski trails doesn't prevent the state government from being efficient. There are other things that prevent the state government from being efficient, but that's not one of them. Also, it may be that the legislature, on complicated issues, that professional legislators may be better at designing complex policy than will voters who are voting on a constitutional amendment. So if something is a very clear sort of issue, maybe the voters are good at making the choice. If it's more complex or has trade-offs, the amendment process, putting something in the Constitution, may not be the best way of dealing with it. Ultimately, then, people talk about putting only fundamentals in the Constitution. And Chris suggested if you passed copies of the New York Constitution around, a lot of people would take their red pens and mark off a lot of things. What would be interesting to see is if people would mark off the same things, or whether or not your view of what is fundamental may be different from her view as fundamental, it was different from his view of what is fundamental. And so to say only fundamentals should be in there, to some extent begs the question, what exactly are we hoping that our Constitution will do? And it may be affected also by the peculiar history of the state. In Hawaii, there's an entire article of the state constitution on Hawaiian homelands, what should be done with regard to land that had been held by the natives of the islands. In Louisiana, there's a provision on the regulation and maintenance of levees. Here we have conservation and canals. Every state has its own particular interest. The conclusion that I would come to from that is that the appropriate length of a state constitution is not self-evident. It's controversial. It depends on what you think that you want the Constitution to do. Chris talked about obsolete provisions. Certainly, you can find those in many constitutions. You can also find constitutional provisions which former law professor at Columbia, Frank Grad, called amendment breeders. The provision is so precise or so limiting that you get a slew of amendments to correct it, slew of exceptions. It sounds like the gambling provision within the New York Constitution may be a similar breeder of further amendments. What can be done? Obviously, you have an opportunity to vote on a constitutional convention in, was it 2017? There hasn't been a unlimited state constitutional convention since, I believe, the 1980s. So this is useful, but it may not be the solution. One of the things a requirement that you vote on a constitutional convention does, it may encourage people to agree to amendments prior to the vote coming up so as to take away some of the issues which might produce a constitutional convention. So between now and 2017, you may have a situation where groups are willing to accept amendments because they fear what might happen if a convention actually took place. Vermont had its judiciary, if you're looking for someone who's presumably nonpartisan, had its judiciary review the entire document, identifying obsolete language and provisions. It would report to the legislature, which could decide whether or not to suggest amendments to eliminate those obsolete matters. So if it's a question of the legislature not proposing because they got better things to do, getting a body outside the legislature, a body that would be trusted by both Republicans and Democrats to make an initial survey is one possibility. Other states create commissions to do that same task. Ohio has a commission they've created within the last year, 10-year working time for the commission, which is to suggest what provisions should be repealed or transformed, and to suggest whether a constitutional convention is necessary or not. So again, that's another possibility, suggest to the legislature. Florida decided on a mechanism, it required a constitutional amendment, decided on a mechanism whereby there's a constitutional commission which meets every 20 years. This commission can suggest amendments. The internal rules of the commission require a 2/3 vote within the commission. They hold hearings throughout the state, et cetera. And once they suggest amendments, those amendments do not go to the legislature, but go directly to the people for their vote. Florida has done this. No other state has emulated them. Certainly it takes a certain amount of power away from the legislators, or the legislators and the governor play a role in the selection of the members of the commission. But the idea is, again, to try and get rid of one of the obvious roadblocks to constitutional reform. One other possibility, and this would again take a constitutional amendment, some foreign countries have a variety of amendment processes depending on what part of the Constitution is being amended. And so, for example, to change the Bill of Rights may require a 75% vote in the legislature to propose the amendment before it goes to the people. On the other hand, there are other things, such as the finance article. You might want a much lower threshold to get changed, because these things may get out of date as a result of passage of time, change in the value of money, et cetera. And so maybe if the problem is the amendment process, the difficulty of getting amendments through, you need to think about whether the first thing to amend is not the finance article or the judiciary article, but the amendment article, to try and make it easier to get obsolete provisions, amendment breeders out of the Constitution altogether, so that then you can get a Constitution that the state can be proud of. Thank you.
Thank you, Alan. The one thing that's kind of ironic is if New York enacted something like that, then we would need a 75% vote to get rid of that divorce provision in our Bill of Rights there. So, all right.
The right to divorce sounds like pretty fundamental to me.
Next, our next speaker is Dan Feldman. He is going to talk about various issues he has, and I will turn the panel over to him.
Thank you. I really like Peter Galey's notion that he presented in the last panel of the Potemkin Constitution. Elements of the Constitution that say something, and then the reality, there are all these workarounds, so the reality bears no resemblance to that. It's sort of, when we're talking about the gambling situation, for example, the Constitution starts by saying gambling, you can't have gambling in New York. It reminds me of, I've learned that not all younger people have actually seen the movie Casablanca, which amazes me. You should certainly have seen the movie. So for those of you that haven't seen it, Rick has been paying off the French Vichy government police chief for years to allow illegal gambling in his casino. But at a certain point, the police chief walks in and says, "There's gambling in this establishment." I'm shocked. So I had this image of somebody walking into New York State, taking a quick look at the Constitution, and says, "There's gambling in New York State. I'm shocked," right? But I'm going to look at 4 other provisions that I think also fall into your category. One, unified court system, right? We do not have a unified court system. The legislators are supposed to look at a bill, have a chance to read a bill for at least 3 days before they pass it. Except for bills that are controversial or important, which evade that mechanism. Legislators are not supposed to saddle the citizens of New York State with debt for a long period of time without a public vote on this matter. Yeah, right. Okay, they've been saddling this. 95% of the debt in New York State was not approved by the voters. There's obviously twists to that, but we'll get into it. And finally, and this one is a little more, I don't know if it fits quite as neatly, but the legislature is supposed to be the main player and the source of general legislation, not the governor. And there have been some developments in recent years which sort of change that. And let me start with that one, because the legislature has come under so much ferocious criticism that there are a lot of people saying, oh, so the legislature doesn't have power. Who cares? Take away the power from the legislature. Let the governor do everything. Now, in the book that Jerry and I put out in 2010, we did not pull any punches about how the various terrible aspects of the legislature. So, despite the fact that I was a legislator for a long time, I'm perfectly happy to criticize them quite fiercely.
Which, by the way, is available for purchase and signature by the authors.
Right.
Anyway, go ahead.
However, at least Jerry and I feel that if you give up on the legislature rather than trying to improve it, you're essentially giving up on democracy, which we're not prepared to do. And so I do think there is a problem when the balance of power between the legislature and the governor shifts excessively toward the governor in terms of substantive legislation. And that has been increasingly a problem for a couple of reasons. One is that in the past, I don't know, decade, 2 decades, I'm not sure exactly how long, more and more substantive issues have been absorbed into the budget process. And in decisions that at least one person in this room knows way more about than I do, I'm talking about Judd Rosenblatt, who's sitting right in front of me, I'm going to dare to speak about this and correct what errors I make. But that balance, I think, has gotten away from where it should be. There's a Court of Appeals decision from 1929 that prohibits the inclusion of general legislation in budget bills. What does that mean? It means that the budget bill is supposed to arrange for financing. It's not supposed to, overturn substantive legislation, specific substantive legislation on other matters. Well, it's not a simple issue, because what if, for example, you have, as you did in 1991, a budget bill that authorized the Commission of the Department of Social Services to change the welfare benefits formula in New York. The court said, well, he's changing it, he wants to change it in order to contain costs. So that's closely enough related to budgeting so that we don't consider that general legislation. So that's okay. But the legislature cannot use the appropriation process, cannot use the budget making process for unrelated purposes. Let's say, for example, and again, this sort of illustrates why it's a difficult issue, nonetheless, let's say the legislature said, the governor sets out an appropriations bill for prisons, but the legislature says, we're adding a provision saying, you've got to reduce the inmate population. You could say that's an unconstitutional substantive add-on, or you could say, well, if you're going to reduce the inmate population, that's going to enable you to limit those costs. So it's also a budget matter. It's not simple to draw the line. But in 1998, in that budget, the governor proposed a new prison in Franklin County in New York. And the legislature said, well, okay, fine, but if you're going to do that, they stuck in the budget, you have to provide for indoor common areas, some kind of space for inmates to have education or other kinds of programming. Governor line item vetoed it. Governor can line item veto in New York. And Speaker Silver sued, saying the governor, the Constitution doesn't say anything about the governor's authority to veto non-appropriation budget language. But since Article 7, Section 4 says the legislature can only strike out or reduce or add items of appropriation in budget bills, the court said the legislature couldn't have imposed that requirement in the first place. Forget about whether the governor could veto it. The legislature wasn't allowed to add that substantive language saying this is indoor common space. 2001 budget, the legislature added conditions to the governor's education appropriation bill. But the governor had already put in that bill changes to the education aid formula. The education aid formula says this much can go to aid to gifted and talented, this much can go to remedial summer programs, various types of educational expenditures. Very complicated formula, but a formula that was enacted through the regular legislative process, not through the budget process. So the governor, in the budget bill, changes the formula. This is like 17 pages. It was a long thing. Again, Silver said the governor's putting in substantive legislation. The court said, no, this is not substantive. These are just the details of the distribution of school aid, therefore budget. In those rulings, the court said, we're not saying the governor can stick in any kind of substantive thing he feels like. The governor said the court, if the governor tried to, if the governor stuck into an appropriation for fire departments, a cap on the retirement age for firefighters. You can't be a firefighter if you're over, 30, whatever it is. That wouldn't be. That's too much. That would be substantive, and we wouldn't let them do that. Or if the state, if the governor had an appropriation for construction project, some construction project, we're going to build, I don't know, a new bridge someplace, and said, and by the way, it's exempt from the scaffold law, which protects workers. We wouldn't allow that. But said the court, this is just hypothetical. We're not in this decision, setting the limits of what is judicially enforceable in terms of substantive legislation. But in allowing, but the court did allow the governor to change the education aid formula, which again had been substantive, in this very long and detailed thing. And Judge Kaye, in her dissent, said, the governor's changes reflected, and I'm going to read this because I want to get the words right, reflected policy determinations. I'm actually putting in some paraphrase to make it shorter. Policy determinations reprioritizing special education, gifted and talented programs, class size reduction, various other things, formerly understood as fundamentally legislative. Therefore, the governor may propose changes to substantive law in connection with the budget, but the legislature is forbidden from altering such proposals. And she says, treating such programmatic policy conditions as simply more specific identification of the item for which he appropriates money is no limitation at all. Everything costs money. If just because it somehow defines the appropriation, therefore it's an appropriate budget item, limits one not at all, because you can find a budget hook for everything. So Judge Kaye, in her dissent, and I strongly agree with this, argued that this decision violates at least the spirit of that 1929 Tremaine decision, which I said, that the governor may not force the legislature to accept his propositions while denying to the legislature the power to alter them. And I would say of the 1927 amendments to the Constitution, which were intended to prevent one branch of the government from forcing another branch to accept conditions that tied to an appropriation that politically you couldn't reject. In other words, what's the legislature going to do? Say we're going to we'll refuse to pass your education aid appropriation because you have these conditions in it? Politically, it's impossible. You're not going to say we're going to vote down an education appropriation. So this system forces the legislature to accept the governor's substantive legislation. So therefore, I would simply add to Article 7, Section 6, something that said any provision prohibited, were it to be offered by the legislature, is likewise prohibited if offered by the governor. Right? Simple, straightforward. Second thing, and this is an old chestnut, this is this borrowing thing. Article 7, Section 11 says the legislature can't basically impose debt on the public without a vote of the public. Now, what's the logic of that? Well, the legislature gets reelected every 2 years. Yeah, you can vote them out after 2 years. But if it's a 30-year bond issue, you got to pay this for 30 years. So you can vote them out, but you're still stuck with it for 30 years. So the idea is the legislature should not be able to stick the public with horrible debt unless the public approves it. Well, this, as I said, this is an old chestnut because for decades and decades there have been workarounds. The result, the main workaround, public authorities and public benefit corporations. Of course, technically, theoretically, these are not debts of the state. But that's ridiculous for two reasons. First of all, even if it's not appropriation backed, and I'll get into that in a second, even if it's not appropriation backed, as we learned in 1975, if the state had let the Urban Development Corporation's bonds, if they had let the UDC default on their bonds, the whole bond market would have said, "Oh, if they're letting that happen, then the state itself's in trouble. So therefore, we're going to, we're going to downgrade the state's bonds, the general obligation bonds, meaning the interest rates will skyrocket." So from a practical point of view, the state does not have the option of not bailing out the public authorities. So yeah, technically, is it debt of the state? No. Really, is it? Yeah, it really is, because the state has to pay it. Even worse, what the legislature has done for many years is they actually vote each year an appropriation to pay the debt. So forget about stream of revenue. They're not even talking about stream of revenue from the public authority anymore. They're straightforwardly saying, yeah, we're going to pay it out of state tax revenues. But of course, since the budget you have to vote a new budget every year, technically they're not responsible for the whole debt because they don't have to vote the appropriation next year legally. But financially they do for the same reason. So again, the state is stuck with this. Now, a couple of very smart people disagree with me on this issue, maybe a lot of smart people, but anyway, at least two that I can think of. One is Charles Brecker and one is Scott Fine. They both basically have said the courts and the legislature have blessed these arrangements for so long that, you know, if you can amend the Constitution, it's been amended before to try to solve this problem. If you amend it again, all you're going to do is the courts and the legislature will find some other way around it. Forget it. It's never going to work. You can't amend this to stop them from doing this. I don't exactly agree with that, because although the Court of Appeals has permitted this, it's always find some way to rationalize the decision. It's always found an excuse to say, well, you know, it's really okay. And I am proposing here a change that would, first of all, make it harder to rationalize at least. And secondly, if it became a big public issue, maybe it would be unpopular enough to do that so the court would stop doing it. And so my change there would say the following. And there'll be some problems with my change too, but okay. My change says, every member of the legislature who has voted for an increase in the authorization of the debt of any public authority or public corporation shall be subject to a recall election, as set forth in Article 3, Section 8, which I would amend as follows. Recall election of legislators shall take place Tuesday succeeding the 8th Monday after such legislators have voted in favor of an increase in the authorization of the debt of any public authority or public benefit corporation. So, that might get their attention. Third, is that third? I want to do different. I didn't want to do that. Let me do a different one. Third, I want to talk about the message of necessity. The Article 3, Section 14, the first part of it says, you can't have a bill be passed until they've read it, until it's been on legislators' desks for 3 days. Why? Well, it's been on the legislator's desk for 3 days. You can be pretty sure some legislator is going to show it to the press, or they'll probably the press will see it anyway. And if it has some really horrible things in it, it'll cause a furor, and people will have an opportunity to fight this thing. Well, there's another little provision saying, except if the governor, and let me get the right words here. Right now it says, unless the governor or the acting governor shall have certified the facts which in his or her opinion necessitate an immediate vote thereon. Well, you know, how are you going to fight this? You're going to sue the governor saying, no, your opinion, that wasn't your opinion. Well, you know, the governor decides what his opinion is. You can't fight that. Well, just as one little example of this, one not so little, pretty big example, but in 2002, that was when Empire State Blue Cross Blue Shield, I have a new tongue too, was privatized, right? This is a $1.8 billion deal that resulted in really horrible shortfalls for county governments around the state of New York. Well, how was this deal done? It was a deal that a lot of people had interest in, particularly Dennis Rivera, the union president, a lot of private sector people. Anyway, the bill was printed on January 15th, 2002, and it was passed at 12:30 a.m. on January 16th, 2002. That is a half hour after the day it was printed ended. It's passed at midnight half hour past midnight on the same day it was printed. This bill did not sit on anybody's desk for 3 days. And it was a deal that was worked among Silver, Pataki, Rivera, and Bruno. So the New York Times said to Silver and Pataki, what is this? How come you don't let anybody see this before you do it? Their answer. And the Times is paraphrasing, so I'm quoting the Times, not them, but they were paraphrasing Silver and Bruno's response. Quote, "Secrecy and a quick vote are necessary on important bills. Otherwise, advocates for special interests, like unions or particular industries, will pick a bill apart before it goes to a vote." I presume they were talking about unions or special or in particular industries that weren't party to that particular deal. Yeah, I mean, individual legislators, the press, and the public are also deprived of the opportunity to pick apart the bill. So this one could be reworded very simply. I would reword this as follows. Unless the governor or the acting governor shall have certified the facts which reasonably necessitate an immediate vote thereon to the facts. In other words, it sounds like a small difference, but it's not a small difference because there is something in law called the reasonable person standard. You can't challenge the governor on what his or her opinion is. You can certainly challenge the governor on what is or is not, what does or does not meet a reasonable person standard. That would make it much more difficult for the governor and the legislature to get away with nonsense like that. Finally, am I running out of time, or could I still have a minute?
All
right. All right. All right. I'll just wrap up with the fourth one, which was the courts. And the court system, we have what is well known as the most Byzantine and complex and archaic court system in the world. And well, certainly in the country. Which one is worse? Which one's worse? Which one? It's worse, but it's not more complicated. The commission, the 2007 Special Commission on the Future of New York State Courts estimated the cost of this fragmentation, just in dollar cost, at $500 million a year. Lost wages, lost productivity, higher costs, and so forth. But it's more than cost. It's pain. It creates real pain for people. Troubled families who as all parts of the same problem, go to the Supreme Court, to the family court, to criminal court for separate adjudication of matrimonial custody and domestic violence issues. You know, especially, I mean, for even a wealthy family, but especially for a poor family, it's a nightmare. In commercial, in other kinds of litigation, anytime somebody sues both New York State and a private party, they're running back and forth from the Court of Claims to the Supreme Court. It's really a problem. It creates horrendous problems. And this could, the commission proposed, and I was part of that commission, and I'm just reporting the simplest part. Actually, this has further implications, but the simplest part of their change would be to say the statewide court shall consist of the Court of Appeals and the Supreme Court, including the appellate divisions and the appellate terms thereof, is hereby provided. The next sentence would then read, the Supreme Court shall include those courts formerly known as the Court of Claims, the County Court, the Surrogates Court, and the Family Court, with the jurisdiction and powers formerly assigned to those courts. And then the section 1B, the second section would say that the Supreme Court, including the district courts and other courts, shall the district court shall include those courts formerly known as the civil and criminal courts of New York City, the district courts of Nassau and Suffolk counties, and the city courts outside New York City. In other words, merging all those courts to solve a host of problems that emanate from the horrible fragmentation of the court system right now. And that's it. So merely those four things will be fine.
All right. Thank Thank you, Dan, for those insightful comments. I'll be very curious to hear how that recall election proposal goes along with your former colleagues there. I'm sure. Both verbally and repercussively. I'll now turn the floor over to a man who needs no introduction, Jerry Benjamin, who's going to wrap this up, and then we'll have some brief discussion. So.
Yeah, I'm going to speak from here. It's your great misfortune that there's no bar against repetition. As I find in my notes that almost everything's been said, so I intend to be brief, so you have a chance. And there are also some variety of matters that have been raised that I'm tempted to comment upon, so that I may go off script for a couple of points. In particular, let me say one thing. There is a way to change the Constitution of New York without going through the legislature. That is to hold a convention. Every state constitution, I think, Alan, has a way of changing it being changed without going through the people who might benefit from the current disabilities of the document. But that very method is blocked because it's become, in fact, contingent on legislative action, either to amend the Constitution on process or prepare for the convention. So there's a constitutional catch-22 that I and others have written about that is only addressable through early action. And then one of the reasons on the run-up to 2017 to have a meeting today is to identify process, or identify that you have to prepare, you have to act, and you create an expectation of action. And if you don't have that expectation, then the failure to act becomes another argument for voting yes on creating the opportunity. And I can detail that further. But on the particular question of length, my colleagues called me and asked, what if we don't want to talk about the length of the Constitution? Well, in fact, all these remarks bear upon the question of length, and it's chosen as a defining point because it's commonly raised as a criticism of state constitutions that many of them are too long. But as Alan and others have pointed out today, the length is an indicator. It's not a problem. It raises the question why, and the question why then brings you to look into the particulars. In response to the call for scholarship, I started where my students do by looking at Wikipedia. Which quotes the Oxford Dictionary. A constitution is a set of fundamental principles or established precedents according to which a state or other organization is governed. Well, the question, as we've heard, is what are the particulars? The frustrations arise, as Judge Wilkinson, the federal Judge Wilkinson, in a law review article wrote in the Duke Law Review, the evolution of many state constitutions. Many state constitutions have evolved into what he calls Baroque collections of essentially statutory material. So there's this federal standard, there's this reality, and there's this frustration. And as has been pointed out, constitutions are longer because they have different work to do. State constitutions have different work to do, and that they are essentially limiting an otherwise unlimited legislature, in theory. Thomas Cooley, the great constitutional scholar of the 19th century, wrote, "We look into the Constitution of the United States for grants of power, but in the Constitution of the state to ascertain any limitations that have been imposed upon complete power." That's the theoretical distinction. Now, Richard Berfault, a great friend of mine, who I regret could not be here today, exploited this point in the justification of the governor's appointment of a lieutenant governor. And if you read his law review article in the Albany Law Review, you'll find that this is not an arcane and irrelevant point. You know, the absence of a limitation allowed the action. And I was on the losing side in those. I'm not an attorney, so I don't file briefs, but I was a named party, as Peter was, in the litigation, and we thought we had a slam dunk, and we were beaten. And the reason was the rationale Richard found in the silence of the Constitution on the matter. Anything not prohibited is permitted. That is not any, and so not if it is not permitted, it is prohibited. Quite different. We've talked a lot about the length in particular. There's another way of measuring. A guy named Hammond wrote an article in the American Political Science Review on this, which was by some miracle published in a political science journal. State constitutional studies are rarely published in political science journals. They're published in law journals. And Hammond counted the provisions, the number of provisions, and he determined their proportion that were, what in his judgment were statutory, and found that New York's number of statutory provisions was not disproportionate. There were just a large number of them because the Constitution was larger. So it accounts statutory provisions in his assessment arise about 35 to 40% of the time in state constitutions, comprise about 35 to 40% of state constitutions. We've heard some of the discussions of why we had this. Chris Bopst was very clear on the incremental and additive nature of the process by which we arrive at state constitutions, and that's a very important point. But a following point that's also important is that constituencies rise for each of these incremental adjustments, and consequently, and these constituencies are additive in their effect when you try to make comprehensive reform. So each constituency has a particular interest, but when you add them together, they have sufficient votes, sufficient force to prevent an overall view out of fear that their particular interest will be compromised in the course of the overall view. And Bruce Jory talked about the interest of public employees in protection of the pension provision, the public pension provision in the Constitution. It's a fundamental and important aspect. When I was advocating for the last convention, working with the former Governor Cuomo, I went to synagogue on the Jewish high holidays. My father's view was that they may be right, so you ought to show up a few days a year. and I was trained in that. That's the degree of my religiosity. I really understated. But I emerged from synagogue and I was attacked by a union attack. I was brought to a stop in front of the synagogue by a union local president who asked me why I was trying to take away his pension, which wasn't an appropriate discussion for the moment, but it was very indicative to me of the nature of the politics I had provoked. And of course, I like to say that 1.6 million people agreed with me on the convention. Unfortunately, 2.6 disagreed. So the politics of that are interesting, and I've written about that. I also think there's a need for a certain humility in reviewing constitutional change advocacy. For example, the militia clause didn't make a lot of sense to me as a contemporary reader until I heard a talk by the Air Guard Vice Commander from Newburgh on what the Air Guard does and its responsiveness in emergencies in the midst of our response to an emergency downstate. So the responsiveness of that force to the governor took on a new importance from my perspective that I didn't understand because I wasn't an educated person about the mission and responsiveness of the militia in New York. So one person's irrelevancy is another person's central concern. I think that if something is non-functional or entrenches inefficiency or obfuscates law and process or diminishes reputation or encourages people to question whether the government itself is legitimate or provokes the pervasive cynicism in government, then we have to take a look at whether we need to have that in our Constitution. So I could specify these criteria in a more scholarly fashion, but that's my. So if you have a provision that says you can't do something and everybody's doing it and it seems legal, that raises in the adolescent mind, that raises the question, what's going on? You know, you don't have to be highly educated or very sophisticated. I'm going to name 2 or 3 examples and stop speaking in the interest of time because I have a role in organizing this event. I've been offended by a bipartisan election administration being in the Constitution. I think it's inefficient. I think it's a locus of patronage. I think that it requires us to hire 2 people for every job we need to hire. I think it doesn't assure professionalism in election administration and is mischievous in the potential convergence between established political interests against insurgent political interests in the state. Now, I don't mean to say that the people who administer elections are bad people or they do a bad job. I'm convinced that people who are recruited by partisan means sometimes are among the most capable people in government. So I'm not presumptively anti-partisan, but I am against structures that are mischievous and that are entrenched in the Constitution and can't be changed because of their constitutional easily changed because of the constitutional basis. The United States chose single-headed departments for its administrative model for a reason. And we have functions where we like multi-headed quasi-judicial functions and so on. So that's a provision that I think we ought to take a look at. We talked about the gambling amendment. We talked about limitations of state and local benefits to private enterprise in the Constitution, or mentioned it, which of course we bypass almost at will out of our urgent need to compete with other states and other places or at least our perceived need to compete with other places to get industry to locate. We talked about state borrowing limits. So this tension between the politicians who want to respond to their felt needs and the Constitution, which says you can't do it this way, is a pretty important overarching theme. And if the legislature wants to act and finds a way to act, as Dan pointed out, it may devitalize the Constitution or take meaning out of it. We shouldn't have a Constitution that is meaningless. We should have a Constitution that's consequential, and the courts feel should be consequential. I think that Judge Kaye wrote in one decision that Peter quoted on the message of necessity that even though, and I'm paraphrasing, unlike Dan who writes laws and actually writes language, I'm a professor, I just freelance. Dan's a professor too, but not a political scientist, he's a trained attorney. Judge Kaye said something like, we've been doing this so long that even though we're not adhering to its spirit, we got to keep doing it. Have I got that more or less right, Peter?
Roughly. Yeah.
Roughly right. That's not what my ideal courts would do. My ideal courts would say, this is what's required, you have to adhere to the rules, and there's a misunderstanding about the rules, or even a judgment that the rules aren't good rules, and we should change them. You know, not leave them in form without having them in fact. I think one of those changes to the Forever Wild provision actually was instituted before we passed the amendment. You know, so, and then we passed the amendment to ratify the action.
The action was unconstitutional.
They took an unconstitutional action, ratified the action with the following constitutional amendment.
Hoped that the voters would approve it.
Well, and the voters, in their wisdom, approved it. So, also, sometimes constitutional questions aren't provoked. For example, that might be, for example, the use of the executive order to affect health exchanges in New York. I'm very interested in what the statutory basis for that action is. I've written on that. The governor took the action. Nobody's raised the question. I think there was an agreement. So sometimes we get no party of interest willing to make the Constitution work, willing to say, whose authority is this? And the matter then becomes entrenched in precedent. And that's a kind of an interesting idea. So we heard about the rebalance of separation. Now I know that John Clarkson is here or was here, and I thought I might have to say something about local government. He seems to not be in the room now. But the local government article is supposed to empower localities and protect the localities. But a side consequence is entrenching local structures, functions, and processes in their 19th century form, and leaving us without effective capacity to change those. Non-coterminality of our local governments is an enormous problem for taxation and administration. We raised, when we had a state commission on this, a boundary commission idea, which I thought was a good idea that Richard Briffault had, that we could put in the Constitution to resolve some of these matters. I've been recently working on assessment. It's very hard to shift the assessment function formally under the Constitution, but what's happening is that informally and voluntarily it's being shifted. So then we have a barrier that's not working, but a barrier that I approve of not working, as opposed to a barrier I don't approve of not working. But nevertheless, there's a constitutional issues. Now, so I think that one of the consequences, I'm going to stop, but one of the consequences of all this is the empowerment of the judiciary beyond what's maybe healthy for the polity. And this is something that occurs not only at the state level, but at the national level. We get decisions in the judiciary that should be in the legislative body. And of course, our legislative body has not been a stellar example of good government lately, but the separation of powers argument still is compelling to me. Let's not forget too that there are people who want to put things into the Constitution. And so should we seek large constitutional change, we would have to consider them on their merits. And my view is that a process that has 3 discrete decisions by the people, one to decide to have a convention, one to empower people to go to the convention and do work, and one to ratify their judgment or reject it, is a pretty careful and considered process, not a high-risk process, but more about that maybe at another moment. Thank you very much.
Thank you, Jerry. We're running a little late, but we do want to have time for questions, so go ahead.
For a number of years, I was a staff member at the state legislature in the Ways and Means Committee. And in that capacity, I had the opportunity to either write or review hundreds of pieces of legislation. One of our favorite, one of our favorite words when drafting legislation was the word notwithstanding, as in notwithstanding the state finance law, notwithstanding the retirement and Social Security law of the state. And our counsel admonished us that there was one thing we couldn't do. We couldn't notwithstand the state constitution. So my question to you is, with people like me out there writing laws willy-nilly and getting members like Dan to pass them, what's to prevent? Why isn't the Constitution too short? Because I can get, as a staff member, I could get things in that made fundamental changes in the law, but I couldn't do it to the Constitution. With the Constitution the way it is, it does protect the people of the state from people like me.
Well, I had a professor once that told me, that used to say Hemingway never wrote statutes, and so I guess that's a very, in terms of what you say, I think there's, as Jerry said, there's this constant tension between the legislative desire to insert or to do, in essence, what it wants to do, what it believes it needs to do to satisfy its constituents, and then you have this constitutional provision that says you can't do this. So I think, if I understand your question correctly, I mean, there's been a significant amount of creativity, as I alluded to in my speech, that has been done to prevent that from happening, but it's kind of like the situation, any system that a person can build, another person can get around or can find a way to unbreak it or crack the code. So I think what happens is that if you try to make it too strict, like what happened is with the gift and loan provision, which says you can't give or loan money, and so there's that provision that's inserted, and then it's too strict and it doesn't allow things to be done. Then you get amendments which sort of relax it, and then you get other efforts to kind of circumvent it. And I think what you're talking about is like a circumvention as opposed to how can circumvention be prevented? Is that kind of what you're?
In lieu of constitutional provisions, it's simply too easy to pass changes to fundamental law, in my opinion.
Well, can I?
Yeah, you go ahead, Dan.
First of all, let me say that if, is this on? I don't know if it is or not. Anyway, let me say that if all the legislative staffers were as competent and responsible as the person who raised the question, Steve Elliott, I wouldn't be worrying about this at all. But I think ultimately you can't get, and this is sort of a reposition or rephrasing of what you just said, you can't get away from some degree of trust in the legislature. What you have to do is get a legislature that hires more people like you and less irresponsible people. I mean, I don't think there's a system of democracy that is viable without some degree of confidence in the ability of the legislature. If we lack that confidence, get a better legislature. You know what I'm saying? I don't think you can solve that problem except by democracy.
I'm not going to comment on this because I think there's a deeper issue here. The Constitution won't solve this problem, that you have the state divided over the value of these limitations on spending, referendum, so there are a great many legislatures who no longer believe these provisions make any sense in the 20th century. They may have made sense then. They're under pressure to do things. There are lots of pressure from other groups to do things. And these provisions are seen as obstacles to needed progress. If the legislatures perceive these provisions as obstacles to effective progress, they're going to do things to get around them, and no attempt by constitution makers to add provisions that will restrict them further are going to work. The problem is we are divided on this question. And the question is whether these provisions bear any relevance to the needs of the modern state. And I think that question New York is divided on. Until we settle that, until we develop a consensus some way about how we're going to do it, constitutions won't stop decision makers from doing what they have to do in the face of these prohibitions.
Any other questions, thoughts, comments, angry rants? Okay, all right. Well, thank you very much for attending. We appreciate everybody's attendance, and thank you.